Let's talk about one of the most powerful, but least understood, tools in the entire VA disability claim process, the CUE, or Clear and Unmistakable Error. Most veterans don't know about it, and very few understand how to use it properly. In this video, we're breaking down exactly what a CUE is, how it works, when to use it, and why it's considered a legal nuclear bomb in the VA world, but only when used correctly. We're also going to talk about the risks, the paperwork, the timeline, the legal rules, and why filing a CUE is often a last resort. Buckle up, because by the end of this video, you're going to know more about CUEs than most VSO reps, and even some attorneys. So first things first, what exactly is a CUE? CUE stands for Clear and Unmistakable Error. It's a special type of claim you can file after the VA has made a final decision, one that you believe contains a very specific and undeniable legal or factual error. This isn't about whether you disagree with the VA's opinion. This is about the VA objectively making a mistake based on the facts and the law as they existed at the time of the original decision. The key word is undebatable. The error must be so obvious that had it not been made, the outcome would have been manifestly different. Now let's talk about the legal foundation for all of this. CUE is governed under 38 CFR Section 3.105A, and it's further backed by 38 U.S.C. Section 5109A for decisions made by the VA and 38 U.S.C. Section 7111 for decisions made by the Board of Veterans' Appeals. Those are the legal codes that define how and when you can challenge a decision based on a clear and unmistakable error. This is not the same as a disagreement over interpretation. This is not about submitting new evidence or getting a second opinion. You are not allowed to use a CUE claim to present new evidence. In fact, that's one of the strictest rules about CUEs. The evidence and law are frozen in time. You can only use the evidence that was in the record when the original decision was made. No updates, no new diagnosis, no new nexus letter, just what was already in the file. So, when should you submit a CUE? The honest answer, only after everything else has failed. A CUE should be your last resort, not your first move. If you've got a bad decision, your first step should be to file a higher level review, HLR, or submit a supplemental claim with new and relevant evidence. You can also appeal to the Board of Veterans' Appeals, BVA. These are usually the better options if you're within the time window and you can add more evidence to support your case. You should never file a CUE before trying HLR or a board appeal, unless you are absolutely certain that the VA made an obvious mistake and there's no other way to fix it. Let's go deeper into why CUEs are so tricky and why most of them fail. The burden of proof is on you, the veteran, not the VA. And it's not just a normal burden of proof like more likely than not. No, to win a CUE, you have to prove that the VA made an undebatable error, so obvious that no reasonable person examining the record could disagree that a mistake was made. And not just any mistake. It has to be the kind of error that would have changed the outcome of your case. So if the VA forgot to apply the right regulation, ignored a medical record that was right in front of them, or failed to follow their own rules, and that mistake clearly affected your rating or effective date, you might have a valid CUE. So how do you actually file a CUE? Unlike other types of claims, there's no standard VA form titled CUE claim form. But what you want to do is submit a formal written request to your VA regional office or the board, depending on who made the final decision. You'll label it as a motion to revise based on clear and unmistakable error. Be as specific as possible. Cite the exact decision you believe contains the error. List the date of the decision. Point to the part of the record where the VA made the mistake. Reference the regulation or law that was misapplied. This isn't a general complaint. You need to lay out your argument like a lawyer would, citing facts, laws, and showing how the outcome would have changed if the error didn't occur. This is why I highly recommend, strongly recommend, that you consult with a Veterans Service Officer, VSO, or an accredited attorney before filing a CUE. Because once you submit a CUE, you are locked into that argument. You don't get a do-over. You can't add evidence. And if it's denied, you can't appeal it the same way you would a regular claim. Qs are reviewed under a much stricter legal standard, and because they involve final decisions, it's basically your only shot at getting the VA to go back and fix something years, or even decades later. And that brings up a very important question. What's the likelihood of a CUE being approved in 2024 or 2025? Unfortunately, the answer is very low. Based on current trends, less than 5% of CUEs are granted by the VA or the board. That's right, over 95% are denied. Why? Because most CUEs are either not actually errors, or they don't meet the strict definition of clear and unmistakable. Veterans often try to use CUEs to re-argue their case or submit new medical opinions, but remember, that's not allowed. The VA is only going to look at what was in the record at the time of the original decision. If your service connection wasn't clear back then, and it's only now that you have better evidence, a CUE won't help you. You'd need to go the supplemental claim route instead. Also, you cannot submit new evidence after a CUE is filed. That's a common mistake. Your claim is frozen in time. Whatever was in the file at the moment the VA made the decision, that's all they're going to review. You can cite errors about how they interpreted that evidence, or how they failed to apply the correct law, but you cannot bring in new documents, updated DBQs, or new buddy letters, and you can't say, "This is what I meant," or "They should have known." You have to prove that a clear legal or factual error occurred that was obvious, indisputable, and outcome-changing. Let's talk about the pros and cons of filing a CUE. The biggest pro is this. If you win a CUE, the VA must reverse the old decision and pay you retroactive benefits as if they had made the correct decision in the first place. That could mean tens or even hundreds of thousands of dollars in back pay. We've seen cases where veterans received retroactive pay going back 10, 15, even 30 years. So when a CUE is valid and granted, it's a powerful tool to correct long-standing VA mistakes. But the cons are just as significant. First, the success rate is incredibly low. As mentioned earlier, most CUEs get denied. Second, they're hard to prove. You have to build a solid legal argument that meets a nearly impossible standard. Third, you can't fix it after you file it. There's no add-on evidence. There's no flexibility. It's a rigid legal maneuver. Fourth, it's time-consuming. It can take months or even years for the VA or the board to process and respond to your CUE motion. And lastly, it can delay other claims or confuse your appeal timeline if not handled properly. Now here's something not a lot of people talk about, even on YouTube. Some veterans try to file CUEs while other appeals are still open. That's risky. The VA might delay both decisions, or they may not process your CUE until the other claim is resolved. Also, if you succeed in your appeal at the higher level review or the board, that could make the CUE claim unnecessary, or worse, moot. That's why we say again, Q is for final decisions that are past the appeal window, where no other options are left, and you're certain a legal or factual error was made. So let's wrap it all up in simple terms. A Q is not just another claim. It's a legal argument that the VA made a serious and undeniable mistake that cost you benefits. It should only be used when the standard appeal options are gone or can't fix the issue. You must prove that the error is so obvious that no reasonable person could disagree, and that the outcome would have clearly been different. You can't submit new evidence. You must argue using only what was in your file at the time. You need to write it clearly and reference the laws and evidence that support your case. And before you file it, talk to a VSO or an attorney. That one conversation could save you years of frustration and give your CUE the best shot at being granted. So now you know, most veterans never hear about CUE, and even fewer understand how to make it work. But now that you do, you've got a powerful tool in your pocket, one that could help you fix the VA's past mistakes and finally get the benefits you earned. If you've got questions, drop them in the comments. If you're going through the CUE process, share your story below so others can learn from your experience. And if this video helped you, share it with another vet who needs to hear it. Thanks for watching, and thank you for your service.